Okay. So this is me. I'm Emilie Goldman. In my professional life, I'm a financial planner, and I'm passionate about creating financial freedom for busy families. And to me, that means freedom from anxiety and worry that build up when we don't plan or we just don't know the next step to take. In my personal life, I'm a mom, and I know how challenging it can be to manage a busy family schedule, and on top of that, find time and energy to focus on the longer term, sort of big picture financial decisions. So I commend you for taking the time today.
Good morning, everyone, and thank you for joining Emilie and myself for the webinar. My name is Brigitte Binkert, and I'm an estate planning attorney. I'm based in Mountain View. And like Emilie, I have my own practice, and I help clients develop and set up their estate plans. I'm also the mom of two children, aged 6 and 9, and like every other parent, I worry a lot about what would happen to my children if something happened to myself and my husband. And while we cannot prepare for everything that will happen to us in our lives, we can at least prepare for some situations. And so during this webinar, I would like to introduce you to the basic estate planning documents everyone should have in place for those situations. And with that, I will hand over to Emilie, who will do the first part of our presentation. Thank you.
Thanks, Brigitte. So I'm going to get the presentation started. And let me switch slides there. So we're going to start by creating some context for all of those financial planning things you know you're supposed to do. I find that many parents I talk to know the components of a financial plan, but they aren't sure where to start and what the priorities should be. Today we'll focus on basic tools. I will cover protection and know your numbers, and Brigitte will discuss your estate plan. These are the tools you need to build your financial foundation. And if you're just joining, I think if you could just mute yourself, that would be ideal. Maybe I can do it here. If you're on the call, go ahead and you can go ahead and mute yourself. Okay. So advanced tools, some other obvious things that would be in a financial plan: retirement savings, college savings, and investment. I would put in the bucket of advanced tools. So sort of once you've taken care of the basics, these are then the things you would focus on. And in the interest of our time today, I'm not going to cover these. I will focus on the basics. But if you click over to my website, events, you'll see things coming up on these topics. So that's one way to learn more, and while we focus on basics today. So protection, this is basically insurance. So life insurance, disability insurance, liability insurance, and then one thing that's not insurance, a contingency fund. So we're going to talk about those things. First off, life insurance, which is something that might be hard to discuss. I find a lot of people put it off, and I also find that it confuses many people. We can easily just get stopped by just the possibility of our own death. And once we overcome that block, we need to figure out what type and how much insurance to buy, and that can really be overwhelming. My financial planning practice is fee only, so I don't sell insurance, but I definitely do help my clients answer these questions and help them find a good source for getting the insurance that they need. One question that comes up consistently is how to decide between term insurance, term life insurance, and permanent life insurance. Sometimes one common type of permanent is called whole life, and you may have heard of that. So what's the difference? A good analogy is that term is like renting and permanent is like buying. Term covers a specific period of time, 10, 20, or even 30 years, where you pay fixed premiums over the term, and at the end of the term, either the coverage ends or you may have the option to convert the term policy to a permanent policy, and you'd have a significant jump in premium for making that switch, but that is often possible. Term overall will have significantly lower premiums than a permanent policy of the same coverage amount. And term ends up making sense for most families because of this. It's low cost, and you can get a lot of insurance for very very low premium. And it's good for families because they typically have large exposure for a fixed period of time while their kids are young. In other words, the impact of the loss of income and or at-home support of one or both parents would have much more financial impact when the kids are grown and self-supporting. So insuring this risk with term life will be affordable for most families. And most employers offer term life as a benefit, so this can be an easy way to get started. But healthy parents will typically find better and cheaper private coverage. And in addition to that, the employer coverage is typically nowhere near enough what most people need. Permanent is, as the name implies, permanent. It's designed to remain in place until the eventual death of the policy owner. So this has its place, but it's for specific situations. If a person is going to owe estate tax when they pass, this is something that would make a lot of sense. If you have a special needs child and you want to be sure you're funding their life support for their living expenses ongoing after your death, like there are specific situations where this makes sense, but for the most part, when we're talking basic, just covering the basic financial obligations, term is going to end up making sense for most people. So moving on to disability, another key component of being financially having a good financial foundation. Disability insurance replaces a portion of your income if you become disabled and cannot work. So since we are all much more likely to face disability than death while raising kids, the impact can be financially devastating. So this is a critical coverage need for most parents. Most employers offer disability as a benefit with the option to option to increase coverage amount from a basic level. So there is something to think about often and something to choose there. And typically it does make sense for people to, if they have the cash flow, to increase that coverage. So this could be an easy way to get coverage. You don't have medical underwriting typically, although it may not be the cheapest or the best. Often employer policies are portable, meaning you can keep the policy even if you leave the employer. If you are relying on employer coverage, you should confirm that this is the case, though. Private coverage can be tailored to your needs and even can be used to supplement a policy you already have through your work. So this is much more complex sort of product than life insurance. Term life insurance, very straightforward. Many companies writing that kind of policy for very similar pricing. So disability is a little more complicated. You definitely want to have some advice around what your specific risks are and how you want to insure that. But it's really an important question. And also for both disability and life, you want to give some thought to, if you're buying your own policy, either life or disability, you will have medical underwriting. And so even though you might not think you need it today, the younger you are, the less chance you're going to have medical issues, right? As you age, not only may you get priced out just because you're older, but if you have medical conditions crop up, it gets harder and harder to buy these things and they get more and more expensive. So it's good to look at these things and even maybe over-insure in the early years just so that you can get good pricing and get access, because risks increase that you won't be able to get the coverage over time. And then the final piece on insurance is liability. So here, umbrella insurance is the coverage that I most often see missing from insurance portfolios of the clients that I work with. And you probably heard this term, but just to sort of lay the definition out there, it's a policy designed to increase the liability protection over and above a standard home and or auto insurance policy. So both of those kinds of policies have liability coverage wrapped up in them. But this sits on top of those. The personal umbrella extends your liability protection beyond those primary policy limits, and it's usually sold in million-dollar increments. An umbrella may be obtained once your home and auto insurance policies meet a minimum. It's called an attachment point. So typically 250 or 500,000 on homeowners or auto. The personal umbrella policies provide 4 elements of coverage. So personal injury, bodily injury, property damage, and defense coverage. And defense coverage ends up being typically a big part of the cost if you are sued. Umbrella coverage can help protect you against personal liabilities that could attack a substantial portion of your assets or future earnings. For a few $100s a year, you may add an umbrella policy or increase your policy limits to sync up with your growing assets and risk factors. So you want to talk, again, an expert in this field is most helpful. A personal insurance agent would understand or help you put this portfolio together. But umbrella is sort of like term life. It's very low cost relative to the amount of coverage that you can get, and it's a real pure insurance. In other words, you're protecting yourself against a potentially catastrophic loss, but highly unlikely, but potentially, if it does happen, it will be a catastrophic size, right? These are big numbers. If you get sued or, if someone passes away, those are potentially huge financial obligations that need to be met. So the last piece of protection here is the contingency fund. Job loss is a likely scenario for most of us, especially here in startup and technology land. Your contingency fund should hold enough cash to cover 3 to 6 months of your household expenses. And that should really be held in cash. And by that, I mean bank accounts, CDs, very short-term bond funds, either cash or funds that could be quickly converted to cash. If your career is more volatile or specialized and requires frequent job changes or longer job searches, you want to be at the higher end of that range, where a 2-income family with some job security might be at the lower end. And here, it's interesting, I haven't seen as much this year, but I don't know, early part of last year and definitely in 2014, I was talking to a lot of clients, a lot of prospective clients who were saying, we have a lot of cash built up. We feel like we should be making it work harder for us. But on further discussion, it becomes clear a lot of that money should actually be in cash because that is the right amount. It's a pretty significant amount for people to have even 3 months of expenses in cash, and that money should definitely not be working for you. It should be in cash. It should be in very safe place where you can access it in case of unexpected need. So the next piece I'm going to cover, know your numbers. So again, the first piece was protection. Here we have knowing your basic monthly expenses, discretionary spending, and future spending goals. And this is a tool that you can access for free. Knowing what you spend is the most important input into a personal financial plan. Unless you know how much you need to live on, you won't be able to calculate how much to save for the future. When you can further break down your spending patterns into basic or fixed expenses, discretionary spending, as well as future spending goals, you have the foundation you need for making wise financial decisions. And I have to say, this is an area where, I don't know, I would say at least 80% of people who come to work with me on a financial plan, like they know they're doing okay, and so but they don't really know specific numbers. And a lot of people, that's sort of when they decide to hire a financial planner, is because they realize that that's important information that they need to really know more and then use that to make choices. But definitely something that you can do on your own. The basic toolkit should also include a way to track your assets and debts. So all of your assets less your debts is your net worth, and ultimately this is the metric for tracking your financial progress. Your net worth will determine your insurance and estate planning needs as well, and will point you towards your financial priorities. Should you pay down debt or save more for retirement or college? There are some terrific free resources available online for tracking your cash flow and net worth, and here are a few of them. I personally started with Quicken. I used that for a number of years, but it really got clunky over time. And then I tried Mint, and I really loved that. So both of those were useful, but mainly they were for looking back at past spending, and that can be important for creating a spending baseline or for preparing taxes, which I was just doing right before this call, writing out all my checks. But both programs for me felt short, supporting me in real-time decision making. So for that, I'm using First Step Cash Management, and I recommend it and teach it to all my clients. I do offer a regular webinar on First Step, and I'll have a few dates going up on my workshop page next week. And that's something that doesn't use software or anything. It's just a system. And actually, I just started looking at this YNAB, You Need a Budget. I don't know if anyone's looked at that, but that in concept is actually, I think, similar to First Step, and I haven't looked far enough to figure out, how exactly it works, but it looks pretty cool. Okay, so we've covered protection and know your numbers. Before Brigitte enlightens us about estate planning, I want to remind you to stay tuned until the end of our presentation, not only for the practical information, because it's going to be great, but Brigitte and I will have a special offer for everyone on the call today. Okay, Brigitte, I'm going to pass it back to you.
Thank you, Emilie. And first, I would like to start with a little roadmap of what I'm going to cover in this second part of the presentation. And we're talking about the different components of a U.S. estate plan. And the basic components will be are a will, possibly a trust, an advance Health Care Directive, a power of attorney, and guardianship for children. In the second part of my presentation, I will talk about how these different components of an estate plan work together and which documents will be used for which situations. And the final part of my presentation will talk about considerations for international estate planning. What are some of the things international families have to think about? And this pretty much applies whether you are an American with assets abroad, or maybe a non-citizen living in the US, or maybe you even have some family members living abroad, and maybe they will be affected by your estate planning. So then let's dive right in and talk about the different estate planning documents. The first document is the will. You are asking yourself, what is the purpose of a will? And it's basically a document where you leave instructions about what should happen to your property after death. If you don't have a will, your property will be distributed according to intestacy laws, which means the law determines who gets how much of your property. With a will, however, you determine who gets how much of your property. So, in my opinion, that's a much better way to plan. And in the will, you name an executor, Sometimes that person is also called a personal representative. The executor is the person who files the will with the court to open a probate proceeding. The executor will also collect your assets, pay your debts, and then distribute the property according to the terms of your will. So it's a very important role. For those of you who have heard about probate but don't know what it is, it's a court-supervised distribution of your assets. So the court will look at your assets and will look how they're distributed and will actually also confirm that it's done in the right way. In your will, you also name guardians for your children and possibly the property of your children. And I'll discuss guardianship a little bit later in more detail. But in a will, you can also provide for pets. That's one other thing you can add. And sometimes a will is used together with a trust. And in that scenario, it's called a pour-over will. And in that case, you will most likely not need to go through probate. And again, I will discuss a pour-over will when I talk about trusts. So we're moving right along to the next document, the trust. And in California, it is very common to have a trust as part of your estate plan. And very often, it's just called a revocable living trust. So I'm going to try and answer, what most clients ask me: what is a trust, and do we really need one? So basically, a trust is a legal agreement under which a person, that would be you, you control property which is given to the trust, and it's for the benefit of another person. So in reality, it's just a document written on paper, and that's the agreement you sign. So if you set up a trust, you transfer your assets to the trust, and you manage the assets as the trustee during your lifetime. And with couples, it's usually both spouses or partners that are the trustees. And by transferring, I mean changing title on your accounts to the trust and also changing title on your real estate. So it's owned by the trustees of the trust. You can revoke a trust during your life, and you can change it as you wish. And then upon your death, the successor trustee takes over and manages the assets and distributes them to the people you name as beneficiaries. So for example, if you had minor children and something were to happen to you, or you and your spouse or partner, then the successor trustee would manage the assets for the minor children until they would get it at an age that is specified in the trust. Or if the children are already adults, the trustee would distribute the assets. So one of the main benefits of a trust is that the successor trustee can actually distribute the assets without the court-supervised probate process. And that also means it's a little bit less costly because probate does cost money. To give you an example, the cost of probate is about 5% of the gross value of your estate, which means the total of your assets, including fair market value of your real estate, your cash and savings, stocks, personal property, but not including life insurance and retirement accounts. So probate can be expensive, and it can also be time-consuming. Depending on how busy the courts are, it can take about a year, sometimes a little bit longer, to get everything done. Another benefit is that distribution under a trust is not public, versus probate is public, so anybody can have access to the documents and look up information. Sometimes clients are surprised when somebody does pass away and they did set up a trust. Then they're surprised that an attorney will still be involved. A lot of times they think, oh, it can all be done by the successor trustee, it will be easy and done very quickly, and that is true to some extent, but in most cases you will still need the help of an attorney with some of the trust administration. But it definitely costs less than having to go through probate, where you pay an attorney for all that work. Then as I mentioned before, even if you have a trust, you would still have a will. It's called a pour-over will. And that will is set up so that any assets that are left out of the trust by accident will then be transferred into the trust with this document. And of course, you also need the will for the guardianship nomination. What's also important to know is that some assets do not go into a trust, and those would be life insurance or retirement assets. Those pass directly to beneficiaries that you name when you set up the account or when you buy life insurance. And if nothing else after this presentation, if you don't decide not to do any further estate planning, but you should always make sure that your beneficiaries are up to date. And a lot of times this can be done online now. So just make sure that you have the people listed that you would like to receive the money. So the question then still is, so do you need a trust? And how do you decide whether a trust is right for you? I would say for most families, a trust makes sense unless there are assets in an amount that can go through a simplified probate procedure. So if you own $150,000 or less, then there is a simplified procedure for probate. But if you have that amount or more, then it's probably beneficial to have a trust set up. And in California, if you own some real estate, you're most likely over that threshold. So that's why it's very common in this area. So then we will move on to the next document that everybody should have, and it's called a durable power of attorney. There are two kinds of powers of attorney. One is a financial power of attorney. The other one is for medical. And I will talk about the financial one first. So what is a durable power of attorney or financial power of attorney? It is a document which appoints someone to act on behalf of the person who created it. And it usually becomes effective if the principal becomes incapacitated. So it's really a simple, inexpensive, and reliable way to arrange for someone to manage your finances if you become incapacitated or unable to make decisions for yourself. So this document is only important in case of incapacity, not for death. The document sort of like expires once you pass away. The person whom you appoint under this document is called the agent, and this person handles your finances outside of a trust if you have one, or all your assets if you don't have a trust. And there are two ways you can make it effective. You can make it effective upon signature or only in case of your incapacity. So sometimes for elderly clients, they want this document to be effective immediately. So they might have an adult child who would like to take over helping them managing finances. And most of my younger clients, they would like for this to become effective only upon incapacity, which often is in case of a really terrible accident where they end up in the hospital and cannot make decisions. This document is actually really powerful, and with it you give a lot of powers to your agent, and I'll give you some examples of that. So with this document, your agent can use your assets to pay your everyday expenses and those of your family. He or she can buy, sell, or maintain real estate and other property. The agent can also invest your money in stocks, bonds, and mutual funds. The person can collect benefits, Social Security or Medicare. They can also buy and sell insurance policies for you. They can file and pay your taxes. They could even operate a business that you own. They can transfer property to a trust if you've created one. They can hire someone to represent you in court or manage your retirement accounts. So as you can see, these are a lot of powers that you're giving. So it's important to know that your agent has what is called a fiduciary duty. So the agent is required to act in your best interests. The person needs to maintain accurate records, keep your property separate from his or hers, and also avoid conflicts of interests. And so when sometimes clients have a hard time deciding on which person they should name, and I usually tell them, pick someone that is good with finances and also has the self-confidence to make financial decisions. And of course, the agent could also hire some help, maybe to make some decisions, but I definitely recommend someone that already is good with managing money. Then we will move on to the next document, which is also a power of attorney, but in California we call it an advanced health care directive. Some of you maybe have already heard of this or have even signed one. Sometimes you are asked to sign one when you're at the hospital, or for women who have given birth, they're asked to sign one when they're in the delivery room or right before. And so this document is a directive to physicians regarding the level of medical care you want if you become unable to direct your own medical care because of illness, an accident, or advanced age. Sometimes these documents are also called living wills, or like I said, durable power of attorney for healthcare. But in California, these two go together and we call it an advanced healthcare directive. So there are basically two things that you do with this document. You direct your healthcare if you're unable to do so yourself, and you also set out the types of medical treatments you would or would not like to receive in certain situations. And that would also include end-of-life decisions, which can be really important if you have specific ideas. Again, I'd like to talk a little bit about what you need to think about when you choose an agent. I think one of the most important criteria is trustworthiness and dependability, and also choosing someone that you think will be good at asserting your healthcare wishes if others argue against them. Because sometimes family members disagree and your agent is really the one who will make the decisions. And so they might need to be firm. And also I've been talking to a couple of doctors about this, and they've all told me it's typically more difficult for the agent to fulfill the wishes. The doctors will always try to save life and do whatever they can, and so if you state your wishes in an advanced healthcare directive, your agent might need to be, again, pretty firm and persistent. So while you don't need to name someone who lives in California, and this is sometimes my international clients ask me that, but I think the person you name should at least be willing and able to travel to your bedside if necessary. And I also always talk to my clients and tell them to consider emotional aspects. It can be very difficult for relatives to make certain decisions, and so you can also consider friends, not just relatives, to become your agents. That would also be an option. So the last component, and that will be on the next slide, I'll talk a little bit about guardianship. When we look at guardianships, and we're really talking about guardians, a guardian is an adult who is appointed to care for the person and or property of a minor child. And the guardian of the child's person must be appointed by the court, but you can nominate a person or several people in your will. So, like I said, if you nominate someone, it does not automatically make him or her your children's guardian, but it does tell a judge what your wishes are. And unless there is a compelling reason not to appoint a guardian, a judge will respect your wishes. And I always tell my clients, if you do not write down your wishes, a judge is going to make a decision without being able to consult with you. So it's really good to write down whom you would like to nominate to care for your children if needed. A lot of times when I have international clients, they have a harder time choosing a guardian because their relatives or friends are living far away. So for those, and even for those who are local and have their families here, I think there are a few important things to think about when you have to make a decision for picking a guardian. So one of the things I always have clients consider is, who is the child most comfortable with? And who really loves and cares about your child? Where would you like your child to be raised? And you should also consider the age of the guardians. How old are the guardians right now, and how old will they be when the child is a teenager? You also should consider the values that the guardian will pass on to your child. Is it important that the guardian share your religion? If you really care about that, then that's also something you should consider. You can also look at the guardian's financial stability, and depending on that, you might need to add some language to your other estate planning documents to help with the finances. And you should also consider whether your child will fit well into the guardian's family, because sometimes you might think that your best friend would be a great guardian, but maybe your own child would not get along with your best friend's children, so that is something to consider as well. And then also you have the you have the opportunity to place some conditions on the guardian nomination. For example, you could say, I would only like these people to be the guardians if they're married or living together. So there are a lot of options for things that you can write down. I also think that it's a good idea to talk to your chosen guardians about this and ask them if they're willing to be nominated. And sometimes I think they will ask, does this mean that I will have to do this if there's ever a need? And then again, you can tell them, this is a nomination. Eventually the judge will decide. And they can always refuse. They don't have to accept a nomination. I also think you should revisit your choices periodically. As children grow, their needs and wants change, and while your toddler might be willing to move to another country or another area in the US, a teenager might be less likely to do so. So if you're in the process of thinking about this, I think it's also a good idea to ask your friends whether they've gone through this and how they decided on a person. I think it's very helpful to talk to other people about this. So with that, we've talked about the main basic estate planning documents, and now I would like to briefly discuss how these documents are connected and in what situations they are needed. So there are two main situations where estate planning documents kick in. The first one is incapacity, and the second one would be death. And I'm just going to briefly tell you in each situation how the documents would work. So in a case of incapacity, and if you do have a trust, then your trustee will manage the assets in your trust, such as real estate, bank accounts, stocks, everything that has been previously transferred into the trust. Then you also would have the power of attorney for finances, and the person named in that document would manage the assets that are not in your trust, such as your retirement benefits, life insurance, or any other assets that you own. And this would also be true if you do not have a trust. If you just have a will, then your agent under the durable power of attorney for finances would manage all your assets. Your advanced Health Care Directive would, in this situation, also come into play, and it would direct your agent to make medical decisions for you. And finally, the guardians nominated in your will might be needed to take care of your children. The second situation, if you were to pass away, then, and assuming you do have a trust set up, then your trustee would manage the assets in the trust and distribute them to your beneficiaries. And the executor would take care of your pour-over will, or if you don't have a trust, then the executor would just handle your will. And that means those two roles, executor and trustee, would collect your assets, manage, and distribute. The Advanced Health Care Directive, in this situation, would direct the disposition of your remains. It also has a section on organ donation, and you can state your wishes for burial or cremation, and you have a lot of room. You can add some information or like some directions that are important to you. In the case of death, the assets outside of the trust, like the retirement benefits and life insurance, usually go directly to the beneficiaries. So sometimes it's a spouse, partner. Sometimes we do name a trust as a beneficiary of those assets, but not always. So then I will move on to the last section of my presentation, in which I will mainly talk about give some tips for international estate planning. The first one would be location of assets. If you're in the United States and you have assets outside of the United States, I think it's very important to talk to an estate planning attorney in the country or in several countries where your assets are located, because every country has different laws for estate planning, and your estate plan in the United States might need to be coordinated with an estate plan in another country. There are situations where you can have only one estate plan and it might work in other places, but it's definitely something that would need to be discussed with a local attorney outside of the US. So just to give you an example, if we have like a married couple from Germany, they have an estate plan in the United States. Let's say they have a trust and they also have a power of attorney and the pour-over will, but they own real estate in the United States and in Germany. So we can, look at the situation, what would happen if they both were to pass away. In the United States, their real estate is in the trust and it would pass without having to go through probate. In Germany, the real estate, is subject to German estate or probate law and cannot be transferred into the US trust. So it would be really important to have something set up in Germany to help with that. I know that in the European Union last summer the laws changed, and it seems like now it's a little bit easier to coordinate, and maybe even one document would be enough. But again, just for my clients, I work with an attorney in Germany and we discuss each client's specific situation, and then me and my clients and this other attorney together, we make a decision on what would be best. For the next slide, we'll talk about the selection of family and or friends abroad. A lot of my clients ask me whether they can name their relatives or friends abroad in their US estate planning documents. And the answer is yes, you can name people abroad in your documents, except for a successor trustee. That person has to be a United States citizen, and the reason for that is taxes. The United States tax authorities want to make sure that the successor trustee cannot take the money and run without paying estate taxes. But you could name a non-citizen and a US citizen as successor co-trustees. So that's an option. For the other documents, or for the other fiduciary roles like executor, guardian, power of attorney, you can name somebody abroad. But again, like I mentioned before, I always tell my clients, I think it's better to choose someone who can speak English, somebody who is willing and able to travel to the US, and also someone who can handle medical and financial decisions, possibly in English. So language skills, medical and financial knowledge, I think, are important skills to have. And then another important point is, and clients again ask me that all the time, you can name the same person to be a trustee, an executor, an agent under your power of attorney, if you like. And I often highly recommend that, because that person then can make decisions and coordinate all the different documents, and oftentimes it's easier for one person to do that. If you have 3 different people or 2 different people, they may not agree on strategy, and then decision making becomes a little bit more complicated. But of course, it's possible, so I'm not saying you cannot do it. So then I would also point out some, or give some tips for guardianship issues. That would be on the next slide. If you are thinking about nominating people abroad as guardians for your children, you should always have some temporary guardians listed in your documents. Just because it can take a while for people to arrive from abroad, it can also take a while for the courts to approve a nomination. So I always recommend naming some friends or neighbors who are close by who could really take care of your children right away. I also encourage everyone to get passports for your children and to keep them current so that a potential guardian could actually travel with the minors without any problems. And like I mentioned before, I think it's also good to revisit your estate plan once the children get older. They may not want to move away and live with guardians in a different country. You know, even though we sometimes tend to think, oh, this would be great if they could live with my sister who is far away, but the children might have a different idea once they're old enough to express it. And then one last point I would like to make is I sometimes have clients who have dual nationalities, and the children, for example, have citizenship for the US, but maybe they're also French citizens. And my clients then would like to nominate some guardians in a third country. We can pick maybe, let's say, Brazil. And so I caution them and I tell them you have to either find out what the immigration laws say or just keep it in mind that if the guardians are trying to take the children to their country, in this case Brazil, the children might have some immigration issues if they're not citizens of the country where the guardians are. That's just something to keep in mind and something that could make it a little bit more complicated. And then, of course, no discussion would be complete without talking a little bit about taxes. Living internationally has, in many cases, complex tax implications, and I am not a tax attorney, but I work with other attorneys who specialize in taxes, and I think there are two taxes that I would like to mention. One, of course, is the income tax, and if you are a U.S. person or a U.S. resident, then you do pay income tax on your worldwide income. For estate taxes, the rule is that in general, each U.S. person can give away $5.43 million in assets during life and at death combined tax-free. When you use some estate planning tools, you might be able to give away more or at least defer some taxation. But if you are a non-U.S. citizen and you have more assets abroad than you have in the U.S., there might be an issue with this estate tax exemption and you might not be entitled to this amount. So in a situation like that, we have to work closely with a tax attorney to determine what the best strategy is and what the best estate plan is for your specific situation. And similarly, if both you and your spouse or partner are not U.S. citizens, special rules might apply. So before you give away any assets, before you do any planning on your own, always talk to a tax attorney to make sure you know the rules. Also, some countries have tax treaties with the United States, and those can be helpful. So again, it's important to find out and discuss it with a professional. A few slides ago, I also mentioned that a successor trustee must be a U.S. citizen. That's also important to keep in mind. And as you've all probably known and experienced, the last few years have brought about an increase in scrutiny from the U.S. tax authorities. So if you have assets abroad, financial accounts abroad, or if you receive large sums of money from abroad, then there might be reporting and compliance rules. So again, if you're not sure, then talk to me or a tax attorney, and we can find out how to best handle the situation. And then on a final note, I always tell prospective clients that estate planning may sound a little bit complicated and intimidating, but it can be done fairly quickly and efficiently. And I also think that it doesn't have to be perfect. You strive for the best and you do what you can, and making some decisions, even if maybe they're not always perfect, is better than not making any. So with that in mind, I wish you the best of luck for your family and your loved ones, and don't forget that you can claim some offers from both Emilie and myself, as I think it's noted on the last slide. Right, Emilie? We have, for next steps, you can request a financial planning readiness assessment from Emilie. And is that deadline confirmed by you, March 21st?
Yes, I was just clicking around here to unmute myself.
Oh, okay.
Definitely. So, right, and you can have access to that, to scheduling that on my website at this link, tamarindfinancial.com, and you'll see some buttons that say "Let's get started," or you can type this whole URL in there, and that gets you to my online calendar. So, be happy to have the listeners today sign up for that financial planning readiness assessment.
And along the same lines, I would like to offer you a free estate planning consultation. We can do it on the phone, or we can meet for a consultation. Just send me an email or give me a call, and we can set something up.
Great. Well, thank you, Brigitte.
Thank you.
That was great. And we're going to wrap. I think we are a couple minutes early. I don't see questions.
I do see a question, Emilie, in the chat. I don't know if only I can see that.
Oh, interesting. Maybe someone just sent it to you.
Maybe. So
go ahead.
I can briefly say what the so the question is, what if we prepare a trust in the USA and then move abroad? Does the trust convert to a foreign trust? So it's possible that the trust becomes a foreign trust if you move abroad. It really depends on what kind of trust you've set up. But I always tell my clients that if you do move abroad, then it is time to revisit your estate plan and see what needs to be done and how it can be coordinated with something in another country. Unfortunately, it's unlikely that you can just keep whatever you have set up and not do or make any changes. So yeah, I think at that point, at least you need to revisit and then make decisions on what makes sense for that next stage or your next place where you live.
Brigitte, even if you change states, like if you're still in the U.S. but you move from California to, say, I don't know, Colorado,
yes,
then you also need to review, no?
Yes, I would recommend that you do that, because states have different laws also involving community property, and some states do not have community property, so you might need to change your estate plan at that point and maybe coordinate it and talk to an attorney in the state where you're moving to see, what parts or which documents can be transferred and would still be enforceable or valid in the new state.
Right. Did something else come in here? Oh, we have a question. I don't know if you can see that. Ariadne says, for folks that move around a lot, can you set up the trust in the first place to not convert to a foreign trust with moves?
So the question is, so it would still be valid even though you move, and it would exist in the U.S. You could do certain things to prevent that. So you could, name a trustee in the U.S. and that person might manage your assets in the U.S. if you move. But a lot of my clients would not want to have a trustee while they're still alive who would manage their assets. So then we're starting to talk about more difficult and complicated estate
Mm,
planning.
mhm.
So that's, I think, how far I can answer this one. If if a client comes into a situation where they move, then we do sit down and most likely also with a tax attorney and do some pre-departure planning and see what makes the most sense. Unfortunately, it's not an easy procedure.
Yeah, it sounds complicated.
Yeah.
But maybe a common scenario around here where people are bopping around the world for different jobs.
Yes, very common, and I think a lot of people who do not even have planning set up,
Yeah.
God forbid something happens to them, but it can get really costly and
Mm,
complicated.
yeah.
Yeah.
So we have another question here. What to do if some assets were left out and not listed in the trust?
So if that happens, then basically your pour over will direct those assets to go into the trust. And depending on the value of those assets, they might have to go through probate before they can be transferred into the trust. So if they're below 150,000, then there's a simplified procedure, like a simplified probate, and then they can be transferred into the trust after that. If they're above 150,000, they would go through probate before they can be put into the trust. Sometimes you can petition a court if it was left out unintentionally. There's a specific petition that you can submit, and sometimes they will, approve it, and then the assets will be in the trust. But again, it's better to transfer before so you don't have to go through all these steps. That's, the purpose of setting the trust up. But at the same time, it does happen, people do forget or unintentionally leave something out. So there are things that you can do.
I have a couple other questions here. One is for kids heading off to college. So, say kids are over 18.
Hmm.
What's the impact like on the healthcare powers? How do you what needs to be done for the kids in order for someone to have healthcare powers for them?
So once they're adults or like once they're 18, they could have their own advanced healthcare directive set up. Before that, it's not possible, and minors cannot have their own directives set up. And I've had clients ask me that before in a situation where something happened to, both the parents and the children, let's say like a really horrible accident, and who would make decisions for the children if the parents aren't around. And I think it would most likely be an ethics committee in a hospital, or they would talk to some close family members. But once they're adults, they can set up their own directives.
Yeah, so that's what I've heard some parents say they've had a hard time helping their kids with healthcare issues. Right,
Hmm.
once they're over 18 and they're, you know, something happens, they need some advice or someone to I mean, especially today, I think kids aren't that comfortable dealing with things themselves. But like, if I just wanted to call my daughter's doctor and say she's 18 and she's away at college,
Hmm.
or she's in the hospital, like they won't necessarily talk to me. Is that right?
I think that's right. So that's why you can set up those documents, and then they will most likely help you with that. But so I think it's a good idea to encourage your over 18-year-olds to consider that. I
Mm-hmm.
personally have not had any clients that age because I think it's not something that teenagers or young adults typically think about, or I could imagine it would be pretty hard to convince them to set this up, but it can be done.
Yeah,
So
definitely. Yeah. I mean, yeah. I don't think kids would necessarily think of it, but parents probably do
yes,
worry what happens if I can't be in touch with medical professionals if something happens.
yeah, yeah. But since the children will have to sign the documents, it's
Yes.
something that they need to talk to them and they need
Yep.
to work with the parents who had it set up. So
Right,
yeah.
right. All right. Well, we're right at 1 o'clock, so I think that's all the questions we can handle for now. But our both our emails are here, I think. Yep. So if you have questions, you can follow up that way. Also, I'm going to send out the recording probably this afternoon. If you missed anything, you can catch it on the recording, or feel free to share that. And thanks again for being on the call. And thanks, Brigitte.
Oh, thank you, and thank you everyone for listening in.
All right. Bye bye.
Bye.